Welcome to season 2, episode 1 of my Two Cents, a Zambian case law podcast with me, your host, George Chintankwa Malipilo. The citation for today's case is Musa, Ahmed, Adam, Yousuf, who was a plaintiff in this matter, who are referred to as Mr. Musa, and Mahtani Group of Companies, Finsbury's Investments Limited, Chamachanga Limited, and Rojan Mahtani. So these were the first, second, third, and fourth defendant. Now, the cause number for this case is 2011 HPC 0081. For those of you who don't know what HPC means, it's the High Court principle and it is a commercial registry. So there are divisions of the High Court where certain matters are taken. So this matter, being of a commercial nature, was commenced in the commercial division of the High Court. Now, the issues for determination in this case were plenty, but I've decided just to focus on the aspect of a legal practitioner and whether one, the legal practitioner, can commence an action in his personal capacity requesting for payment of legal fees, and secondly, whether the legal practitioner can practice and represent clients independent of the law firm. The brief facts of the matter are that Mr. Musa, a Zambian legal practitioner, was working with the firm A.D. Adams and Company. Now, this firm represented the first and fourth defendant as its advocates. They were rendering legal services as a result. Now, Mr. Musa, upon rendering these services, was not paid for the work that was done. And as a result, the defendants owed Mr. Musa 275,000 US dollars and 347 million US dollars for the services rendered. As a result of this, and having provided them the legal services, Mr. Musa decided to sue the defendants in the High Court under the commercial division. Now, like I said, this matter had a lot of other legal issues. So some of the legal issues were very technical, and I thought it wouldn't be prudent for me to just talk about them because the whole essence of the podcast is to not give legal advice, but just to provide legal awareness of certain legal issues, like I will do today. So the defendants made an application to strike out the writ of summons and the statement of claim, and they were asking that the matter be dismissed, but we will not focus on that. However, what we're focusing on is what the court first decided to do in this matter. So the court said they wanted to determine whether or not the plaintiff, Mr. Musa, as a legal practitioner, in his own capacity, can commence proceedings in the High Court. That was the issue that the court had to decide. Now, the ruling of the court, or the ruling of Judge Nigel Mutona, as he was then, because he is now a Supreme Court judge, but back then he was High Court, so we say as he was then, came to the conclusion that since the plaintiff provided legal services under the umbrella of his law firm, A.D. Adams, it is only the legal or the law firm that can institute an action for payment of his legal fees, and he couldn't do it on his own. According to the judge, the legal practitioner cannot claim the fees in his personal capacity as he has no sufficient stake in the funds to enable him to do so. Now, the court ruling was based on Section 36 of the Legal Practitioners Act, Chapter 30 of the Laws of Zambia. Now, we will discuss in detail when I look at the judgment under the My 2 Cents segment later on. So we will discuss what Section 36 of the Zambian Legal Practitioners Act means. Now, as a result of what the court had ruled, among other things, that matter was dismissed, and the court stated that the plaintiff lacked the capacity. As such, the action could not be sustained. So the matter was dismissed, where Mr. Musa was suing the defendants for providing the legal services based on the fact that the law firm should have been the one to commence the matter and not Mr. Musa, because he had no sufficient stake. in the funds to enable him to commence it. So that's how they decided to dismiss the matter. So my 2 cents on the case at hand are, firstly, one, we need to actually read section 36 of the Legal Practitioners Act of the Republic of Zambia so that we get an understanding of what this specific provision of the law says. Now, section 36 of the Legal Practitioners Act states, and I quote, every person applying for a practicing certificate shall. Now, when you are reading any provision of the law, and I'm just giving this out as advice, not as legal advice, but just as advice for those who are legal students, those who are Ziali, those who read the law. Each word that you read matters. And the type of interpretation that you're going to be undertaking also matters. So here, these words, we will apply the lateral meaning. So we'll interpret them based off the ordinary meaning of these words, because there is no ambiguity and it won't cause any drama or problems at the end after interpreting it. It's straightforward. Unless when we read it, problems arise or ambiguities arise, then we would have to use a more appropriate interpretation. So statutory interpretation. So that is something that you can Google and learn about. Anyway, the understanding of the words I've just written out are: everyone who wants to practice as an advocate of the Republic of Zambia needs to apply for a practicing certificate. Now, the term every practitioner includes those who are getting admitted to the bar. It says every practitioner. It doesn't give a limit on the year. So meaning even the early students from the Zambia Institute of Advanced Legal Education who have just cleared and are going to the bar need to apply for a practicing certificate. The mere fact that you cleared Ziali does not mean that you are now a lawyer. No. You need a practicing certificate, and you need to apply for it. Now, notice the word shall, meaning shall is mandatory. So every practitioner in the Republic of Zambia who's an advocate, who's going to court, has to have a valid practicing certificate. If you don't, you will be in trouble. Anyway, that's for another day. So, as I have read, every practitioner applying for a practicing certificate. So these are the things you need to do if you're applying for a practicing certificate and you're a practitioner, a legal practitioner, qualified. 1, obtain from the association a certificate showing that he is a member in good standing of the association. The association means the Law Association of Zambia. So you need to be of good standing. Secondly, to get that practicing certificate, you need to deliver to the association a written declaration in the prescribed form stating the name and place of business of the applicant and the date of his admission and signed by the applicant. Now, at first glance, when you read it, you would just gloss over it and say, okay, fine, he just needs to write in a prescribed form his name and the place of the business and the date of his admission. So when you got admitted to the bar, I got admitted on the 29th of August 2022. So I would indicate that and I would sign it. But notice the words prescribed form stating the name and place of the business of the applicant. It essentially means when you are applying to the Law Association of Zambia for your practicing certificate, it is mandatory you state the name and the place of the business you are working for. This essentially means under Section 36, every practitioner who is applying is viewed or seen to be working for a company that is registered under the Companies Act or a partnership, but it has to be a company, a legally acceptable company that is allowed to trade, or a partnership. Notice the words doesn't say the name and the place of the firm. No, the name and the place of the business. So it can be a mining company, it can be a shoe factory, it can be a water company, a media company. They just need you to place down a place of business. Therefore, Section 36 sets the tone in that for you to practice law in Zambia and call yourself a legal representative and represent your clients, your various clients, maybe as company secretary, you need a place of business for you to represent those clients. If you don't have that, you cannot come up and practice law without being associated or connected to a company, meaning you provide your services under the umbrella of the law firm. So my 2 cents take on it is a Zambian advocate or a practitioner is not independent from the place of business they work from or from the law firm that they work from, as can be seen from this case. So therefore, you can only practice law and represent clients or a client in this country through a named law firm, as can be seen from this case, or through a named business. So meaning, let's say the workers' compensation can only be represented by a lawyer who has a place of business. And if your place of business is at the workers' compensation, you can represent them because you've got a practicing certificate and you have a place of business. Further, the legal fees generated from the work done on behalf of a client or client are fees that belong to the firm and not the legal practitioner because you don't have any sufficient stake, as was the decision in that case. In this case, sorry. Further, an action for payment of legal fees can only be commenced by the law firm. Meaning, if you render legal services and someone owes you, a practitioner in his own right cannot commence a matter, but it has to be the law firm. Because, like I keep on repeating, the legal practitioner has no stake in the funds to enable him to do that. As I have also stated, Section 36 of the Legal Practitioners Act, or the case of Musa versus Mahtani Group of Companies and others, for me also highlights the fact that when you are admitted to the bar as an advocate to practice law in Zambia, the mere admission of you being admitted, the mere admission, if that's the right word I can use, does not therefore automatically give you a qualification to practice law and represent clients in Zambia, unless otherwise, or at least there may be exceptions to the general rule, but the general rule is you can't practice without having a practicing certificate that shows that you work at a specific place of business and the address. And also, you then have to be admitted to the bar, hence code. So you can't practice without having been called to the bar by the Chief Justice. And you're not a legal practitioner without having been given a valid practicing certificate. Therefore, what this case is bringing out is legal practitioners in Zambia have no right to represent clients, a client, or companies without working for a business or a partnership, law firm. You need to be working somewhere and give us that address to the Law Association of Zambia. This is why lawyers who get admitted to the bar and have no place of business cannot represent any single client. The client needs to have a lawyer who is working for a business. Law firm, a company you can represent. So if I got admitted to the bar today and I have no job or no place of business, I cannot represent any individual who wants me to represent them as the advocate. That is not possible. So therefore, the general public, I'm sure, wonder why sometimes when someone tells you, "Oh, I'm a lawyer, but I am still looking for a job," and they would ask, "Oh, why can't you represent me?" They'll tell you, "Look, I can't because I don't have a place of business." This is why Section 36 of the Legal Practitioners Act, and also the interpretation that that section has been given as a result of the Musa, Ahmed, Adam, Yousuf case. So, hope you learned a few things. I must reiterate that this is not a podcast that is giving you legal advice for you to find legal solutions. No, this is a podcast discussing Zambian case law and the importance of that case law. That's it. So, thank you for tuning in into today's episode. I've been your host, George Chintanko Madipilo. See you next time when we have another episode. Bye.